Hey everyone, I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today I'm going to talk about what happens during a uncontested divorce trial or uncontested divorce hearing, it's sometimes called. So an uncontested divorce hearing is basically when you go in front of a judge after a divorce has been negotiated and you have a fully signed divorce agreement and financial affidavits. Now, ever since COVID, you can actually finalize your divorce without having to have a uncontested divorce hearing by submitting certain forms to the court, and they can actually finalize the divorce, what's called on the papers, which means just based on submitting paperwork, they'll finalize the divorce. You don't have to go in front of a judge. But sometimes a judge may have questions about an agreement where he wants the parties to come in and do the divorce in person, or sometimes, a divorce might be negotiated right before trial, so it's easier to just appear in front of the judge and have the uncontested hearing rather than submit the forms you need to submit for the divorce to be finalized on the papers. So again, you'll have all of the final divorce documents submitted to the court, which is usually the divorce agreement, financial affidavits, if there's children, child support guidelines. Those are kind of the basic forms. So you go in front of the judge, and if you don't have lawyers, then the judge will ask you a series of questions. But if you do have lawyers, usually your lawyer will be the one who's asking you questions about the divorce agreement. Some judges might want to canvass, it's called canvassing, so asking questions of the parties. Some judges might want to ask questions of the parties themselves rather than the lawyers doing it. But usually if there's lawyers involved, the lawyers will ask the questions. So again, you'll appear in front of the judge. The judge will put the parties under oath, and then I'm just going to, for the sake of this, I'm going to assume that there are lawyers involved. So the lawyers will ask a series of questions. Usually the plaintiff goes first. The plaintiff is the party who filed the action. And the lawyer will, kind of the standard questions are, you were married on so-and-so a date. So name the date of the marriage in Brookfield, Connecticut, or Newport, Rhode Island, wherever you were married. And then, you'll answer yes. And you've lived in Connecticut for at least the past 12 months, which is kind of, there's a number of ways in which Connecticut can have jurisdiction over a divorce, but usually the parties have lived in Connecticut for at least 12 months, which allows you to finalize the divorce. And I'm going to create a separate video that talks about divorce jurisdiction and when Connecticut has jurisdiction over a divorce. So if you haven't lived in Connecticut for the past 12 months, you can watch that video. And the lawyer will say, has your marriage broken down irretrievably with no hope of reconciliation? Yes. And you have no minor children, correct? Correct. Or if you do have children, the lawyer will say you have two children, Thomas, date of birth, so-and-so, and Christopher's date of birth is so-and-so. And one thing they will ask, or the judge will ask, is if it's a woman who's being questioned, that you're not pregnant right now, so you're not expecting any other children. Or if it's the other party who is the female, they may say, and your wife isn't pregnant now, and you haven't received state assistance or town assistance or Husky health insurance during the course of your marriage. Or maybe you have, in which case you answer yes. And you've reviewed the agreement in detail, correct? And you've had time to read the agreement. And then after that, the lawyer will likely go through all of the individual provisions of the agreement. Not in like the most detail, but they'll go over certain provisions. So they'll go over alimony and say, you've agreed to certain alimony terms. Or if there is going to be no alimony, usually the lawyer will ask, will say something to the effect of, you understand, you're not receiving alimony, and you understand that you can't come back to this court or any other court in the future and ask for alimony. And they'll go over child support, division of assets, etc., and usually go through all of those provisions and kind of scan them to make sure the judge understands everything that you're going over. After all of the provisions are reviewed, the lawyer or the judge will ask, you understand the agreement. You've had time to ask questions about the agreement of your lawyer, or if you don't have a lawyer, you've had time to consult with a lawyer. You've had the opportunity to decide to consult with a lawyer. And you believe the agreement is fair and equitable. You believe the agreement is in the best interest of your children. Nobody's forced you to enter into this agreement. You don't have any side agreements. You understand by entering into this agreement, you're waiving your right to go to trial. So rather than entering an agreement, you could have presented your case to a judge with witnesses, evidence, etc., and you could potentially have received a different result than what you're agreeing to here. And you understand that, correct? And then basically, do you have any other questions about the agreement? And, so those are kind of the basic questions. The judge may have some follow-up questions that they want to ask just to cover themselves and make sure you understand all of the provisions. And then, then there's no more questions for the plaintiff. Then next, the defendant will go. So if there's no lawyer, the judge will ask the defendant questions, or if there is a lawyer, the defendant's lawyer will ask questions. So again, they'll ask, you confirm that you were married on so-and-so a date. You've lived in Connecticut for at least the past 12 months. They may not go over all of those provisions. What they'll probably say is, you heard the testimony of your spouse, and do you agree with everything that your spouse said during his or her testimony? And you heard your spouse's attorney, or you heard the judge review all of the provisions of the agreement with your spouse. And did you hear that testimony? And did you understand all of the provisions that were reviewed? And do you understand all of those provisions? So that, it kind of shortens the process, where the second lawyer doesn't have to go over every single provision of the agreement again. So they'll just say, do you substantially agree with everything your spouse said? But what they will review again is, you've had time to review the agreement, you've had time to read it, you understand the agreement, you've had time to consult with an attorney if you don't have an attorney, or if you do have an attorney, you've had time to ask questions of your attorney. You agree that the agreement is fair and equitable and in the best interest of your children, that nobody has forced you to enter into the agreement. You don't have any side agreements. You understand that you're waiving a right to have a trial by entering into this agreement. And again, asking if they have any questions about the agreement. And then again, the judge may ask some follow-up questions just to make sure that they're really comfortable with the agreement. And then, during the uncontested hearing, there may be, maybe the judge doesn't understand something. A judge might say, all right, I don't quite understand this. Why don't you guys take a break? You need to fix this language. You need to fix that. In which case you go out in the hallway, hopefully fix it and resubmit it. So those are kind of the basics of the questions that are asked during the uncontested trial. And then, if everything goes smoothly, then the judge will, find that the agreement is fair and equitable. They'll go through a whole series of statements. They'll declare that the divorce is finalized, and they'll declare you divorced, and that is your official day of divorce, the day in which the uncontested trial happens. And then what the judge will usually tell you is that it takes the courthouse some time to process the paperwork, and then you should be able to pick up a certified copy of the judgment within a week or two, within some reasonable period of time. Every courthouse is different. So those are the basics of how a uncontested divorce hearing works. If you have any questions, as usual, feel free to give our office a call.